Back here in the U.S. at this hour, Supreme Court Chief Justice John Roberts with a rare public pushback against President Trump. What he's saying about the president's call to impeach a federal judge blocking the Trump administration's deportation flights. And President Trump just moments ago reacting to the Chief Justice.
Well, you go to the Ninth Circuit and it's a disgrace, and I'm going to put in a major complaint because you cannot win if you're us a case in the Ninth Circuit. And I think it's a disgrace.
Donald Trump spent years celebrating Supreme Court victories that expanded presidential power. But now, after a direct court order blocked parts of his immigration crackdown, the same president who praised the judiciary is being accused of openly defying it. That single decision has triggered a constitutional firestorm in Washington, including a new impeachment resolution known as H.Res 353. Legal scholars are warning that this may become the most serious separation of powers crisis America has faced in decades, with enormous consequences heading into the 2026 midterms. If no president should ever stand above the Constitution, subscribe now and stay with us as this unprecedented battle unfolds.
Have breaking news tonight, a deeply divided moment playing out in American history as we come on the air. President Trump has just been impeached on both Article 1, abuse of power, and on Article 2, obstruction of Congress. The votes down party lines as predicted. And all day long here, we've been watching the short bursts of anger, the closing arguments from both sides.
The Supreme Court has no military force and no independent enforcement arm. Its authority survives because presidents of both parties historically accepted one basic principle: even when they disagree with a ruling, they still obey it. The moment that tradition breaks down, the constitutional system itself becomes unstable. Donald Trump has spent years attacking judges whenever rulings failed to go his way. During his first term, he repeatedly described the Ninth Circuit as a disaster and accused federal courts of sabotaging his immigration agenda. But despite the rhetoric, his administration ultimately complied with court orders while continuing to fight through appeals. This time may be different. The current crisis began after months of legal battles surrounding Trump's second-term immigration crackdown. Civil rights groups and immigration attorneys challenged several executive actions involving rapid deportations, asylum restrictions, and detentions carried out without full hearings. Lower courts repeatedly ruled against parts of the administration's approach, arguing that certain policies violated constitutional due process protections and existing federal immigration law. Trump's allies dismissed those rulings as judicial activism designed to undermine border enforcement. Then the cases reached the Supreme Court. Initially, Trump celebrated the outcome as a massive victory. The court narrowed several nationwide injunctions and reinforced the idea that presidents retain broad authority over immigration enforcement decisions. Conservative commentators immediately framed the ruling as proof that Trump's aggressive border policies were legally justified. But behind the celebration was a second, far more dangerous development. The Supreme Court also issued direct instructions requiring the administration to restore certain asylum protections, halt specific deportation procedures, and make documented efforts to address cases involving migrants allegedly removed improperly under expedited enforcement operations. Those instructions carried the force of law, and according to critics inside Congress, Trump's administration began resisting compliance almost immediately. Administration officials reportedly argued that immigration enforcement falls primarily under executive authority and that courts cannot dictate operational border policy in real time. Trump himself continued publicly attacking federal judges while insisting he had a historic mandate to secure the border by any means necessary. That response triggered alarm throughout Washington because the issue was no longer immigration policy alone. It became a constitutional question about whether a sitting president could selectively ignore a direct Supreme Court order simply because compliance conflicted with his political agenda. Democratic lawmakers responded quickly. H.Res. 353, a new impeachment resolution introduced in the House, accuses Trump of violating the constitutional separation of powers by refusing to fully comply with binding judicial authority. Supporters argue this is not merely another partisan clash, but a direct challenge to the foundation of American government itself. And politically, the optics could not be worse for Trump. For years, he praised Supreme Court rulings whenever they expanded executive power or benefited his administration personally. He celebrated emergency rulings, conservative justices, and the shadow docket process that repeatedly handed him victories during both terms in office. Now, critics argue the same president who applauded judicial authority suddenly rejects it when the court imposes limits on his own actions. Presidents absolutely have the right to challenge rulings through appeals and legal motions. What they do not have is the constitutional authority to treat Supreme Court orders like optional recommendations. Once enforcement becomes selective, the presidency itself begins drifting beyond the rule of law. That is why many constitutional scholars believe this confrontation may become one of the most dangerous presidential power disputes America has faced in decades. Impeachment was never designed for ordinary political disagreements. It exists for moments when Congress believes a president is placing personal authority above the constitutional system itself. That is precisely how supporters of H.Res 353 are framing this confrontation. Within hours of reports that the administration would not fully implement the Supreme Court's immigration directives, Democratic lawmakers began drafting impeachment language accusing Trump of abuse of power and deliberate defiance of judicial authority. By the following morning, the resolution was formally introduced and immediately sent into committee review. And suddenly, what began as an immigration fight transformed into a battle over the survival of constitutional limits themselves. The resolution argues that Trump's refusal to comply with the court represents a direct assault on the separation of powers established by the Constitution. According to lawmakers backing the measure, the danger extends far beyond border enforcement. If a president can openly ignore Supreme Court rulings without consequences, then judicial authority becomes effectively meaningless. That argument is already gaining traction among constitutional scholars and former federal officials, because America's legal system ultimately depends on voluntary compliance from the executive branch. The Supreme Court can issue rulings, but it has no independent military force and very limited enforcement power. Historically, presidents complied because refusing to do so threatened the legitimacy of the entire system. Trump's critics argue that the line is now being tested publicly for the first time in generations, and politically the stakes are becoming enormous. Republicans now face a dangerous dilemma heading into the 2026 midterm cycle. Defending Trump completely risks alienating moderate and independent voters who still believe deeply in constitutional checks and balances. But breaking with him risks provoking fury from Trump's base, which still dominates large sections of the Republican electorate. That tension is already visible inside conservative media. Some Trump allies insist the courts are overreaching into executive immigration authority and argue the administration retains broad discretion over enforcement priorities. Others, including several conservative legal analysts, appear far more cautious. Their concern is not necessarily immigration policy itself, but the precedent created if presidents begin openly deciding which Supreme Court rulings deserve obedience. Once one president successfully ignores the court, every future president inherits that precedent. The constitutional danger extends far beyond Donald Trump personally. That warning may explain why this impeachment fight feels fundamentally different from Trump's previous two. The Ukraine impeachment revolved around foreign policy pressure campaigns. January 6th centered on incitement and election certification. Both cases involved emotionally charged factual disputes that allowed supporters and critics to interpret events through partisan lenses. This situation is structurally simpler. The Supreme Court issued directives. The administration allegedly resisted compliance. Congress is now debating whether that resistance itself constitutes an impeachable offense. That clarity creates serious political danger for Trump, because even voters exhausted by years of investigations may still react strongly to the idea of a president placing himself above the judicial branch entirely. Democrats already appear prepared to make that argument central to the 2026 midterms, framing the election as a referendum not simply on Trump, but on whether constitutional restraints still apply to presidents at all. And behind the scenes, Senate Republicans reportedly understand the risk few expect immediate removal from office. Conviction in the Senate would still require a massive political rupture inside the Republican Party. But even without removal, the impeachment process itself guarantees months of hearings, subpoenas, media coverage, and constitutional debate dominating Washington. That sustained pressure could become politically corrosive over time, because every new hearing revives the same central question hanging over Trump's presidency. If a Supreme Court ruling only matters when a president agrees with it, then what exactly remains of constitutional limits on executive power? The real constitutional danger is not whether Trump wins this fight politically. It's whether the country quietly normalizes the idea that presidents can ignore court orders whenever enforcement becomes inconvenient. That may ultimately become the defining issue of this entire crisis. Because beneath the non-stop political noise, something far more fundamental is being tested in real time. Whether America's constitutional system still possesses the ability to restrain executive power once a president decides the limits no longer apply to him. And history offers a warning here. Legal scholars have increasingly compared this moment to one of the darkest constitutional episodes in American history. Andrew Jackson's refusal to fully respect Supreme Court authority after Worcester v. Georgia in the 1830s. Although historians still debate the precise wording of Jackson's response, the broader message became infamous. The Supreme Court had ruled, but the president effectively chose his own path anyway. The consequences were catastrophic. Critics now fear Trump is moving toward a modern version of the same constitutional collision, particularly because immigration enforcement touches enormous questions involving executive power, national security, and civil liberties all at once. And unlike earlier presidential controversies, this dispute feels unusually visible and direct to the public. There is no hidden transcript, no anonymous whistleblower, no complicated financial structure for voters to untangle. The accusation is simple. The Supreme Court issued a binding order. The president allegedly refused to fully obey it. That simplicity makes the political danger far more serious than many Republicans initially expected. Constitutional systems rarely collapse in dramatic explosions. More often, they weaken gradually as institutions stop enforcing boundaries they once considered untouchable. That gradual weakening is exactly what many legal experts now fear. Because if Congress ultimately fails to respond in any meaningful way, future presidents from either party may inherit a dramatically expanded understanding of executive power. The message becomes dangerously clear. Court rulings only matter when the White House voluntarily agrees to follow them. And once that precedent enters the system, reversing it becomes extremely difficult. Trump appears fully aware of the gamble he is making. His political strategy has always relied on forcing institutions into confrontations they hesitate to sustain. He is betting Republican lawmakers will fear his voter base more than constitutional backlash. He is betting the public will eventually grow exhausted by another impeachment fight. And perhaps most importantly, he is betting that political loyalty will once again overpower institutional restraint. But this time, even some longtime conservatives appear increasingly uncomfortable, because this fight is no longer simply about Donald Trump. It is about whether the presidency itself remains constrained by law. And that is why the 2026 midterms may evolve into something much larger than an ordinary election cycle. Voters will not only decide which party controls Congress, they may also decide how much constitutional authority the judicial branch still possesses when confronting a defiant president. For now, the crisis continues to escalate. The impeachment resolution moves through Congress. The administration continues defending its actions. The Supreme Court watches carefully from above the political battlefield, and hanging over all of it is one deeply unsettling question. What happens to American democracy if a president discovers the courts cannot force him to listen? Donald Trump has survived scandals, investigations, and impeachments before, but this confrontation may prove different because it strikes at the very core of the American system itself. If a president can openly resist a Supreme Court order without consequence, the balance between the branches begins to collapse. Over the coming months, Congress, the courts, and the voters heading into 2026 will all face the same defining question. Does the Constitution still place limits on presidential power, or have those limits become purely optional?